The AIRE Centre is a legal charity that has an almost 30-year history of using European law to protect individuals' fundamental rights. This has involved running a range of different projects across a range of different countries. The EuroBrits project that is currently being run at the AIRE Centre is one such project. Through the EuroBrits project, the AIRE Centre assists UK nationals and their family members in Bulgaria, Greece, and Norway who would not be able to complete the relevant process without additional assistance, with applying for the correct residence document now the UK has left the EU. This involves assisting UK nationals who, for example, live in remote locations, who experience significant difficulties with dealing with the national authorities or the national bureaucracies, who are perhaps not computer literate, or who find themselves in particularly complicated immigration situations. I am going to give a brief overview of the legal background to this project. The Withdrawal and Separation Agreement protect the residence rights in their host state of UK nationals who were legally residing in Europe by the 31st of December 2020, the date which marked the end of the transition period. So what does it mean to be legally resident? In the case of UK nationals who have lived in their host state for less than 5 years, legally resident means they must have either been a worker, self-employed, a student with comprehensive health cover, self-sufficient with comprehensive health cover, or a family member of someone who falls into one of the previous categories. For those who have met these conditions for a continuous period of 5 years and who have therefore acquired the right of permanent residence, are also considered legally resident for the purposes of the Withdrawal and the Separation Agreement. The Withdrawal Agreement and the Separation Agreement allow European countries to adopt either a constitutive or a declaratory system for certifying these rights. In a declaratory system, UK nationals have the right to continue residing in their host state simply by virtue of having been legally resident in the country by 31st December 2020, the end of the transition period. It's important to note that being legally resident does not mean they had to have been physically present in the country on the 31st December 2020. In a declaratory system, UK nationals are encouraged to apply for the new residence document, which will act as evidence of this right. However, a failure to apply for this document will not affect their residence rights and they still retain them, simply by virtue of having been legally resident in the country by 31st December 2020. In a constitutive system, UK nationals have to apply for a new residence status. All those who were legally residing in the country by the end of the transition period will be eligible to apply for this new status. A successful application by the deadline set by the host country, which cannot be earlier than the 30th of June 2021, is a condition for retaining the residence rights that were held by UK nationals under EU law. In either case, it is important for UK nationals to apply for the new residence documents. Even in a declaratory system, it will often be necessary to prove that you are a beneficiary of the withdrawal or separation agreement when engaging with national authorities, and holding the new residence permit will be the easiest way to do this. You can find more information on this project and on the process of applying for the correct residence permit in Bulgaria, Greece and Norway at the AIRE Centre website.